Good morning, Liberty. It is Wednesday morning, March 27th, 2019. My name is Michael Boldin, broadcasting to you live for the 10th Amendment Center from here in my downtown LA home office and studio. It is 9:30 a.m. Pacific time here on the West Coast, so good morning to you, good afternoon, good evening, whether you happen to be watching live or later on in the archive or listening to the podcast, whatever it may be. I'm very grateful for you spending some time with me today. Now, on this episode, I had recently come across an article from a website that you might think is very supportive of our work on the right to keep and bear arms by a guy who you'd think would be supportive of our work on the right to keep and bear arms. That is just awful. This is done by a relatively well-known firearms attorney, pro-Second Amendment guy, pro-gun rights guy, and he is attacking in this article efforts to nullify federal gun control, primarily in Missouri, but also by basically anywhere that's trying to do this. And the article was so bad. I was going to write a response to it, write an article and submit it to the website. But I figured there's just so much to cover. I'm just going to talk about it in this show. And I'm going to go through as well as I can, piece by piece, talking about the junk that this guy comes up with. I don't know how this man can be a firearms attorney and know so little about what he's talking about, just leading him down this rabbit hole. But before doing that, I'm using a new chat app that I've been trying to get accustomed to for Restream.io as we broadcast simultaneously through YouTube, Facebook, and Periscope. So I'm just going to kind of scroll through the live chat and say hello to some of my friends before we get into the articles that I want to cover today. There's Tyler, Bob, Dennis, Dan, Anna, Jim, Sherry, Kevin, Justin, Joe, Billy, Alan. I appreciate you guys. I know I'm passing up a bunch of people. It combines the chat messages from all the platforms into one place. And I'm going to figure out, I might actually set up a laptop or another screen here to make this a little bit easier for me. But even if I missed your name, I'm very grateful for you spending some time with me today. Thank you so much for being here. Let's get into this discussion. First of all, there is a little, there's some prerequisites for this show, basically. There are two episodes that I covered in February that I think are very important background information for what I'm going to talk about today. First of all, and again, all the show notes should be included both on YouTube and Facebook if you're watching live or in the archive. We don't get to do that on Periscope and Twitter, but if you just want to find all of the information for all of our shows and find all of the shows that we've done since it started back in 2018, mid-2018, it's 10thamendmentcenter.com/Good Morning Liberty, all spelled out. 10thamendmentcenter.com/Good Morning Liberty. The first episode that I'm going to reference, I'm not going to cover it in any detail here, but if you really want to get some background info and you haven't listened to all the shows, this is a Supremacy Clause Smackdown episode from February 13th is very important. And then also the anti-commandeering episode, the legal basis for refusing to cooperate. That was on February 20th, also here in 2019. Those two episodes, again, the links are in the show notes at 10thamendmentcenter.com/Good Morning Liberty. And then also I want to briefly cover the Missouri bill that this firearms lawyer is going to town attacking over at concealednation.org, I believe. concealednation.org. Which, from what I've read, has got a lot of good content there. So I was really disappointed to see how poorly done or researched this particular thing that I'm going to cover here in a moment was. So first of all, Representative Jared Taylor, our Republican from Republic, introduced House Bill 1039 on February 21st of this year. Titled the Second Amendment Preservation Act, the legislation would ban any person, including any public officer or employee of the state and its political subdivisions, from enforcing any past, present, or future federal acts, laws, executive orders, administrative orders, court orders, rules, or regulations that infringe on the right to keep and bear arms. And it's a companion bill from Eric Burleson in the Senate, Senate Bill 367. So I believe in Missouri it's the exact same language in both chambers, but it's been filed in both chambers. It's in committee in the Senate. It has not been sent to committee in the House yet. If you live in Missouri, I know Robert and a number of other people who watch pretty regularly are in Missouri. Suzanne as well. If you are in Missouri, you definitely want to call your state rep and state senator and ask them to co-sponsor House Bill 1039, and on the House side and on the Senate side, Senate Bill 367. That's if you like what we're talking about here today. And if you're in Texas, I know like Bob and Ward who join us so regularly, it's House Bill 238 that you want to get a co-sponsor for in Texas. So the bill itself bans the use of state personnel or resources to help enforce federal gun control measures. Basically all of them. It includes a list of things that would apply that they're not going to help enforce, and it's not exhaustive. It specifically says this is including this but not limited to. So, for example, taxes and fees, registration and tracking, forbidding possession, and then any act ordering the confiscation of firearms, firearm accessories, ammunition, like a bump stock ban, for example. So this includes the National Firearms Act of 1934, the Gun Control Act of 1968, etc. Basically, our view is that all federal gun control measures are illegal and unconstitutional. The ATF shouldn't exist. The right to keep and bear arms is a natural right, and the federal government has no authority to do anything under the Constitution to restrict your right to keep and bear arms. But that's a side note. So let's get over to Phil Nelson. This is an article that he wrote over just a couple of days ago on the 22nd, concealednation.org. He's a nationally recognized firearms law attorney, expert witness, college professor, author and co-founder of Legal Heat, the nation's largest firearms training firm. And sometimes when you see stuff like this, and the article is just garbage, which this article is, I'm sorry to be unkind, but it is, if you have these types of qualifications, and I Googled the guy, he's actually done a lot of good stuff, I think, and he's legit. He's not just making this up. He's got real credentials, in my opinion, from what I Googled. But when you have some credentials, you shouldn't write the kind of garbage that we're about to go through. Or maybe being an attorney isn't all that it's cracked up to be. You don't really know what you're talking about all the time. I don't know. Let's look at this. The article says, understanding the supremacy clause and why federal nullification laws could land you in prison. He talks about two phrases, and I can't do the Latin because I'm no legal scholar, but let's get into them. Ignorance of the law is no excuse, and not knowing the law is harmful. And I think these both apply to what Phil has to say in this article. And he goes on and writes, there appears to be a large and dangerous misunderstanding about this topic of nullifying federal gun laws within the firearm world. And he talks about this recent article from the Sentinel, which was covering efforts in Missouri, Senate Bill 367 and House Bill 1039. The original post of it actually was covering, as if it would just happened, a bill that was passed by one chamber. The state Senate 23-10 was the vote back in 2014. And I think someone must have pointed out, because I was tweeting and we were putting out some information, like there's a lot of information spreading about an old bill as if it's new. So they did change the report to talk about the legislation that's currently being considered. And so Phil goes on and he writes a little bit, he quotes part of the law, talking about how all these federal acts that I was just reading, acts, laws, executive orders, etc., that violate the right to keep and bear arms will be invalid in the state, shall not be recognized by the state, shall be specifically rejected by the state, and shall be considered null and void and of no effect in the state. They're basically saying that the state is not recognizing. And then it goes on in more detail to ban the use of resources to enforce these particular things. So he goes on and he says the Missouri legislature, he kind of goes off on the Sentinel article, and even in its revised version at the same link, there's some hyperbole. So I'm with him on that. They're definitely a little bit over the top. I think it's a very good piece of legislation. It's going to do a lot of good should it pass, which is why there's a lot of opposition from the gun control community on this type of thing. But he says the Missouri legislature may have the best intentions in the world, he actually wrote, but they won't do anything of real value by passing this law, and it is extremely important that gun owners understand why. So this is a person who clearly thinks that immigration sanctuary cities are totally fine because they do nothing. Banning the enforcement of a federal law on the books has no effect on that federal law because he's saying passing something like this won't do anything of real value. Now, you don't have to be in support or opposed to immigration sanctuary cities to recognize that a large number of states and cities banning the use of resources to enforce federal immigration law has done a great deal to impact the federal government's ability to do that. In fact, ICE puts out an annual report and they talk about how states like California, by not participating with them, make it so much more difficult for them to carry out their ERO operation, enforcement and removal operations. So ICE knows this. Why doesn't the ATF? Maybe the ATF does and they don't want it to get out. Why doesn't Phil Nelson understand this? We know that James Madison in Federalist 46 told us that states and individuals should refuse to cooperate with officers of the Union, and doing so would create impediments that the federal government, quote, would hardly be willing to encounter. That's the father of the Constitution. We also know that Judge Andrew Napolitano has told us that a single state banning state resources for the enforcement of a federal gun law would make it nearly impossible to enforce. Now, I would like totally impossible to enforce, but banning resources is a highly effective way of really pushing back. It is a very good foundation. Now, Judge Knapp, James Madison, I'm going to go with their opinion over Phil Nelson on this particular type of approach not working. Now, mind you, Phil is totally clueless about the bill that he's reporting on because he doesn't actually realize that the bill is doing what I'm telling you. But you can click the links in the show notes and read the text of the legislation and read it for yourself. He thinks it's something different. So that tells me he's writing this blog attacking the legislation without having read it or without having the ability to comprehend it. Either way, that is dangerous. Someone should not be doing that. That is dangerous propaganda, in my opinion. Now, maybe he doesn't have bad intentions and he's just going off. He's just making the mistake of trusting what he read somewhere, and he's confused, but he isn't really doing research. That is also dangerous. Someone who is claiming to be a leading resource for firearms laws really should do their homework before they talk about something. So this is what tells me he's clueless. He says, first, some background. Missouri would not be the first state to enact one of these laws. Roughly 10 other states have enacted very similar laws in the past decade. Totally false. The only states that have done this, first of all, was Idaho banned the use of resources in 2014 for any new federal gun control measures. Not all, past, present, and future. Alaska has a bill from a few years ago that would ban the use of resources for some federal gun control, but it's not clear how it really, what triggers it, no pun intended, or pun intended, to actually go into effect. And Tennessee Tennessee and Mississippi have some foundational first steps. But the only one that's actually expressly banned the use of resources is Idaho, and it's only for new federal gun controls enacted after the effective date of that particular law. So he's already confused about what this is, and he's actually thinking it's a different law, which is known as the Firearms Freedom Act. This was originally drafted by someone I consider a friend and a great activist on the right to keep and bear arms, Gary Marbut in Montana, the Montana Shooting Sports Association, or Sports Shooting. MTSSA.org is his website. He's done such great work in Montana for many years. In fact, many times on strategy, especially on the local level or the state level, I often defer to Gary in Montana, Wyoming, and elsewhere because he's so good at this. So he drafted this bill, the Firearms Freedom Act, which would make it legal in a state to, as long as it's a in-state made. This is a Commerce Clause issue. If you make a gun in state and you keep it in state and you're not crossing state lines and it's stamped made in state, the legislation takes the position that the federal government does not have commerce power under the Interstate Commerce Clause to regulate that firearm. And then that particular law has been passed in somewhere between 8 and 12 states. So he's already referring to this as the wrong. He didn't read the bill that he's complaining about, that's saying dangerous. He doesn't know what the hell he's talking about. And he's writing this entire article about something totally different. So he says, for example, Montana, Idaho, Utah, Wyoming, Arizona. I don't think Arizona passed one. Alaska, South Dakota, Kansas, and Tennessee all have their own versions of these laws on the books. The laws, often called nullification laws or firearm freedom acts, seek to make virtually all federal laws regarding firearms inapplicable within the confines of a particular state. The basis for doing this is that firearms made, sold, or produced entirely within a single state are theoretically not subject to interstate commerce and therefore not subject to any federal regulation. I agree with that notion. If you keep something within state, it is not interstate commerce. Again, this is not the bill that's being considered in Missouri, and so he's attacking it strategically. And there are things to be said strategically about firearms freedom acts, which I have supported in the past, but I think at this point we are going beyond to better strategy in the future as we learn what works and what comes into roadblocks. So he's talking about these bills that are only, first of all, he's also saying, so he's talking, everything I'm highlighting in blue, if you're watching, is a falsehood. So first of all, he's saying this won't do anything of real value. This is his opinion. I think it's just garbage. Then he says Missouri would not be the first state. There's 10 other states. That's false. He lists a bunch of other states that passed a law like Missouri's. False. They're different laws. And if you're a lawyer, you should understand that saying that something is the feds have no authority under the Commerce Clause is totally different. Totally different than saying your state is just not going to help. Totally different. He said the basis, okay, so all these things are false. He also says it's important to note up front that these laws have lost each and every single legal challenge that they have ever encountered. He makes it sound like there's been a ton of cases on this. There have been 2. One in Montana, which I'm not versed enough to speak on. Gary, maybe, if anyone sends him this, would give me an update on that, what's going on in Montana. I think they lost on appeal. But no one was prosecuted in Montana. And then another one in Kansas for the same type of Firearms Freedom Act where 2 people, well, there were 2 cases. One where the Brady campaign sued the state and it was thrown out. So the state actually won. And then the other one where 2 people were prosecuted. Very light punishments in comparison to what has happened in previous efforts on similar approaches strategically. Still bad. But only 2 cases. He makes it sound like there's been a ton of these. Totally wrong. He says, I am, however, aware of many instances where otherwise law-abiding gun owners, including my own legal clients, have relied on these laws and found themselves being criminally prosecuted. I think that's a lie, personally. I mean, it's possible there are a lot of people getting prosecuted under these Firearm Freedom Acts. I'm not aware of them. I only know of 2 people. Shane Cox and Jeremy Kettler in Kansas. And that is a serious problem there, but we can talk about that. I want to do a full episode on that. I'll only touch on it briefly here. But I believe he is just making this part up. Maybe I'd be happy to know that other people are trying to defy the feds. I don't want to know that people are getting prosecuted, but this is nonsense. Now he's also talking about the Missouri law and then comparing it to a totally different thing about cases that aren't happening. So he's just, in my opinion, making this garbage up as he goes. The cases aren't happening. Then he goes into the Supremacy Clause. And again, I'm going to refer back to, okay, he also says, I'm not aware of a single time one of these laws has been upheld in court. Now, mind you, if you're talking about the Firearms Freedom Act, which the Missouri bill, House Bill 1039, Senate Bill 367 being considered right now, they are not that. They are based on the anti-commandeering doctrine, banning the use of resources to enforce the federal act. This, if you refer back to my anti-commandeering episode on February 20th, again, link in the show notes at 10thamendmentcenter.com/goodmorningliberty, you'll learn that this is based on James Madison's advice in Federalist 46 to stop participating in federal enforcement, to refuse to cooperate with officers of the Union, in his words. And then at the same time, the Supreme Court, while I don't want to defer to the Supremes on anything, they certainly do back up this strategic approach. And they have from 1842 to 2018. I cover 5 major cases in that episode where the Supreme Court has specifically backed up this approach. And maybe this lawyer, Phil Nelson, would know that if he knew the legislation. Now, I'm not trying to say that he doesn't know what the anti-commandeering doctrine is, although a lot of legal types have ignored this for many years. We have pushed this to the mainstream in many ways in the last 5 years or so. I would say 7 years ago when I was talking to people who are trained lawyers, a long time, friendly to our work, and I would say anti-commandeering doctrine, they would often say, oh, I know I should remember this from my law school days, but you got to refresh my memory. And I'm no lawyer, but so a lot of lawyers are just not familiar with it, maybe, or they've forgotten about it. They focus on other precedent. So he's totally wrong in that as well. I don't know. What are we up to? Like 6 things that are just nonsense in his article? The next thing he says, the Supremacy Clause says when state and federal law conflict, federal law always wins. Now, he is totally making up what the Supremacy Clause says. It does not say that anywhere. It specifically does not say that. And if you listen to my episode on the Supremacy Clause, you'll learn that the founders actually debated this, and they actually rejected the idea that the feds held a veto power over all acts of the state governments. Instead, they came up with something that said the federal law is supreme when its acts were in pursuance of the delegated powers of the Constitution. So this is the worst statement that I think I could find in there. Because even if he was talking about the proper bill, he is just clueless on the constitutional structure, thinking that federal laws always win. Federal law always wins. This is garbage. Again, referencing back to the Supremacy Clause episode of February 13, 2019. So he says, the reality is nullification laws do very little other than get gun owners arrested. Sit down and comply. There's no risk. Don't take any risk. And he talks about the Montana law. Again, comparing this Firearms Freedom Act, this Commerce Clause challenge, which is only saying that the feds did not have commerce power, not taxing power, which is really what the court actually held that it was under the National Firearms Act, for example, but commerce power. He's correct on that. But this is not what the Missouri bill is, once again. And then he talks about the Kansas bill, 2013. And then he talks about Shane Cox and Jeremy Kettler. They relied on the promises made in the Kansas law and began manufacturing illegal firearms. I believe it was firearm accessories like sound suppressors. He calls it a silencer here. Homemade silencer. Don't use that term. It's wrong. I used to use it all the time. I feel like we still do on the website. And I want to start scrubbing that because it's a lie. It's not really a silencer. It's a sound suppressor. But let's look at what happened. He says they were doing this. They were relying on it. Well, according to Mr. Cox, he knew exactly what he was doing. This is after he received his federal punishment of, I believe it was a year probation. Kettler got a 1-year probation and $100 payment. Cox got 2 years probation and $800 fine. Not good. But in comparison to a very similar thing, marijuana under the Commerce Clause, in the early days here in Southern California, almost everybody who was getting arrested for something like this, for having a plant, even though the state was pretty much backing them up. And for example, in places like West Hollywood, the city was signing on the lease for dispensaries in the city. So you had government support. That did not happen in Kansas. They did not support these people at all. They probably, at least from my understanding, the local law enforcement actually did logistics and helped the federal agents, making it even worse. But in the early days on the marijuana issue, people were going to prison for 5, 10 years. One prominent guy in West Hollywood, I believe, or maybe just central LA, died in prison. So I don't want to discount the fact that these two gentlemen got 1 and 2 years probation. I wouldn't want that. It's a horrible situation. But in comparison, we're far further along in the nullification efforts, in their success and in their punishment than it was 20 years ago. Now, mind you, Mr. Cox knew exactly what he's doing. This is what he said, quote, "Someone had to take one for the team. I was doing it out in the open. It wasn't a secretive thing." So he was actually doing this on purpose. And Mr. Nelson claims that they were totally relying on this to protect them, and I don't believe that based on Mr. Cox's statement. I could be wrong, but that's how I'm reading it. And he says this case is one of the many that highlight the problems with nullification laws. They do not provide you with the protection they purport to provide. Now, first of all, I don't think they're actually claiming that the state is going to go in and protect someone. I know a lot of people want them to do that, but the states aren't going to do that. States are bad guys too, and no one should be making the case that you're protected because of a state law. But we do know that when enough people say no, when enough people defy those 5,000 ATF agents, which are supposed to cover the entire country, and enough states pass laws backing them up, they're not going to be able to pull it off. We've seen this happen with 33 states on weed. We see it happen in immigration sanctuary cities, and sooner or later, we're going to have to see more people have the courage of people like Shane Cox and Jeremy Kettler. It can't just be 2 people going it alone. It can't. Otherwise, it'll never be successful. And of course, Thomas Jefferson, he said, put it this way. This is my quote of the day a little early here. But we are not to expect, let me start that again. We are not to expect to be translated from despotism to liberty in a feather bed. We're going against the largest government in the history of the globe. It is not going to be easy, and it's going to take a lot of courage. So no one should make the claim that there's a silver bullet, pun intended, or that this is going to be easy, or that there's no risk. There's a risk all the time that you break a law, whether it's a speed limit law or a marijuana prohibition law or a gun law. There's always a risk. I do also want to point out that the first time that this went to court, the Brady campaign sued the state of Kansas, and a federal judge threw it out. They just said it was thrown out, so the Kansas law is still on the books. It was not struck down as unconstitutional. And the federal law was also not struck down. So it was thrown out. So in many ways, that's a win for the state, but it does take people actually following up. And that's where I pointed out in this report back in 2015. Oh, no, this one was TJ Martinell. That was not my report. I apologize, TJ. So he said, should local gun manufacturers start acting outside of federal law, and should Kansas law enforcement serve a complaint on a federal agent, it's likely to be challenged by the federal government, with the federal courts likely to side with Washington, D.C. We told people that the federal courts were not going to side with the state law. But one part of the bill was not being challenged at all. Even the Brady campaign did not challenge it. And that's a section of the bill that sets the foundation for state and local agents to refuse to help implement federal gun measures. And of course, they should follow up on that in Kansas. They haven't yet, because they think that this Firearms Freedom Act is the end of the road. They don't have to do anything more. But no, localities and the entire state should specifically and expressly ban the use of state, local agents and resources to enforce federal gun laws. And maybe the ATF wouldn't have had help in doing this. Now, maybe they would have been able to pull it off because it was just 2 people. But sooner or later, we're going to have more and more people do this in large numbers. I'm not sure if this is making sense at all. I hope you find it interesting, educational, insightful, fun to watch, all that stuff. I'm grateful for you spending some time with me today. I do want to cover the Kansas case in more detail in a future episode. I definitely will be doing that at some point. But I really, really appreciate you joining me. And again, I want to do a quick reminder that I will not have a live show on this Friday or next. I've got some important things scheduled, a meeting, and then I'm doing an event for the California Libertarian Party Annual Convention a week from Friday. So I will be off on those. I might try to get a pre-recorded video done in time, but I'm not 100% sure. Again, I'm rambling at this point. I'm very grateful for you spending some time with me today. I hope you enjoyed the show. Please smash the like button. Continue leaving comments, whether it's live or in the archive. Ratings on iTunes helps a lot. And thank you so much for watching. I'll see you next time here at Good Morning Liberty.